Okay, good morning, everybody. Today we are going to be starting with the groundwork of Chapter 1, Legal Framework Affecting Public Schools. So we are going to be getting all into the Constitution, into our federal government, into our state government. And I'm going to start off with, like I said, kind of the footwork of our government, which is the Bill of Rights. The Bill of Rights represents a primary source of individual rights and freedoms under the U.S. Constitution. As we know, it makes up the first 10 amendments of the Constitution. They are viewed as the fundamental liberties of free people because they place restrictions on the government's power to intrude on our fundamental rights of all citizens. So these restrictions simply mean that the government cannot exercise certain powers in the relationship to free people. So, for example, the government cannot pass laws prohibiting the freedom of speech. So keep in mind, the Bill of Rights only limits the federal government's power, not the state government, which we're going to be talking about a little bit later. Now, getting into the federal Constitution, the Constitution of the United States is the basic law of the land. It provides a framework of law in which orderly governmental processes operate. The Constitution thus becomes the primary source of law. Now, as we know, because of the Constitution, we have a national government consisting of the legislative, the executive, and the judicial branch, which divides the power between the federal government, and it also gives the power to the state as well. Now, all statutes or written laws enacted at the federal, state, and local levels, as well as the state constitutions and local regulations and ordinances, are subordinate, which we know is lower in rank than the Constitution. The federal Constitution is distinguishable in its provision to protect fundamental rights of all citizens of the United States. So we just know in basic terms that the federal Constitution lays the groundwork for all of our rights as citizens in the United States. Inherent among those rights are those involving our personal rights, property rights, and political freedoms. Now, although the Constitution does not make a reference to education, which we're going to be talking about because a lot of those rights were given at a state level, it does impact the operation and management of schools, particularly with respect to amendments, which protect the individual rights of students, faculty, and staff. Now, getting more to a state level and what our rights are based on the state level, based on the 10th Amendment, which we know reserves education as a state function, thus placing primary responsibility for public schools on individual states. So based on the 10th Amendment of the federal Constitution, powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectfully. So we know in the past, before 1868, one important factor concerning the 10th Amendment were that states were not abiding by their own Bill of Rights. So the 14th Amendment was adopted, which guaranteed that due process or fairness of students and school personnel to ensure equal protection under the laws and fundamental fairness occur in matters involving deprivation or the denying of liberty and property. State constitutions represent the basic source of law for individual states and generally require legislative bodies to perform various functions, including establishing systems of public education. So they prescribe funding and operational schemes for public schools. Now, state constitutions may exceed coverage granted by the federal constitution, but they may not fail to meet the basic requirements of the Constitution or contradict it in any manner. So, state constitutions, one thing that we have to keep in mind is that they address the same subject matter found in the US Constitution. We have due process, which is fairness, individual rights and freedoms, and keeping in mind the very important one, the separation of church and state.
So now moving on to statutes. Okay, statutes represent an act of the legislative branch of government. Statutes are the most abundant source of law affecting public schools and the public education. And then school district policy, rules, and regulations are generally based on statutory law. Statutes represent the most effective means of developing new law or changing old laws, and then state legislators grant local school boards the authority to adopt and enforce reasonable rules and regulations necessary for the operation and management of schools. And this is because of the 10th Amendment that Megan talked about, where the Constitution didn't say anything about giving power to the federal government for education. So that's why state legislators are giving local school boards the ability to make policies, statutes, as long as they don't go against Constitution or other federal law. Now talking about the difference between court and case law. So case law is generally reflected in judge-made or common law as distinguished from statutory law. And then common law also consists of judgments, opinions, and decisions of courts adopting and enforcing preceding usage and customs called precedents. And precedents are just past court decisions, if you didn't know that term. Now moving into the state boards of education. So state boards of education are administrative agencies created by the state legislature. They determine to some degree the direction of education in the state. Public schools are placed under the control of the state boards of education. And as many of us know, state boards may develop policies covering a bunch of different topics such as health and safety, teacher licensure requirements, graduation requirements, and then others that are relevant to the education needs of their state. And some of these other things that the state boards establish are state testing programs, establish standards for accreditation of school districts, and teacher administration preparation programs. And then they also deal with the budget review and acceptance for the state, and then help develop rules and policies for administration of state programs. Now moving to the local school boards. So local school boards impact education policy and the administration and supervision of public schools within their district. Their broader role involves the formulation of school district policy, which must be consistent with the state statute.
Right. Oops, go ahead.
And then these policies may be accompanied by rules and regulations that provide direction for the operation of schools. And then, whenever there's a chance in the state statute or even federal law, local boards of education, administration of districts must review and update policies if need be. So if there's ever a change in any federal law in the Constitution or the statute, then local school boards have to do due diligence, understanding that change, and then change their handbook and their school policies about that topic.
Okay, our country has two forms, basic forms of courts of system. The United States has a court system that is made up of two levels. We do have a local level, but we won't be talking about that. The judicial system in the United States includes the federal and state courts with similar structures. Both levels of the court system consist of trial courts, intermediate courts of appeal, and the U.S. Supreme Court. State constitutions define the authority and jurisdiction of state courts, which must resolve cases presented to them. Courts do not independently rule on the constitutionality of laws unless a legal challenge is filed. Courts have three main functions. They're settling disputes, interpreting laws, and determining the constitutionality of the legislative or administrative directives. The legal precedents guides courts in interpreting vague laws, and courts can influence the meaning of laws through their interpretations. In federal courts handle cases involving federal or constitutional matters and cases with parties from different states. The federal court system includes district courts, appellate courts, and the Supreme Court, with a total of 95 federal district courts in the United States. Appellate courts review lower court proceedings for legal errors, ensuring proper application of law and constitutional interpretations. The largest ones, of course, are New York and California. You can go to the state courts. State courts address cases related to state laws, statutes, and common law, excluding federal matters. State courts have a structure similar to the federal courts, including general jurisdiction courts, special jurisdiction courts, limited jurisdiction courts, and appellate courts. Discretionary jurisdiction allows parties to petition the state Supreme Courts to readdress issues, giving the court the power to decide on case acceptance.
We've got to go back some to courts of general jurisdiction. And there we go. So the courts of general jurisdiction are also known as district or circuit courts. Their jurisdiction covers most cases except those held for special courts. Decisions of these courts may be appealed to intermediate courts or even to the state Supreme Court, which includes civil, criminal, traffic, and juvenile issues. And now let's talk about the courts of special jurisdiction. They hear legal disputes on special matters. They are referred to as trial courts with limited jurisdiction. They may be called municipal, justice of the peace, probate, or small claims or traffic court. Now, the intermediate appellate courts. So they've emerged over the past 3 decades to hear appeals from trial courts or certain state agencies. Their primary role involves reviewing proceedings from trial courts to determine whether substantial or procedural errors occurred in applying the law. Their duties are similar to those of the highest court, but the main difference is discretion. The intermediate court has less discretion in accepting cases than does the highest or the state Supreme Court.